God, do not turn off the engine right now. Officer, this is my vehicle. I live here. I have done nothing. Stop resisting. I am Judge Avery Hale. This is my driveway. Officer Gage Voss had spent enough years on the Crest Hill Police Force to build a reputation and enough time to accumulate a quiet stack of internal complaints, several for excessive force, several more for racial profiling. Every one of them investigated internally, everyone dismissed, no suspensions, no formal discipline, no paper trail that ever made it past the department's legal division. His personnel file used careful, coded language, highly proactive, detail-oriented, takes initiative. Behind the euphemisms lay a pattern anyone outside the station could have seen. He escalated situations, and more often than not, the person who triggered his suspicion had black or brown skin. A young man in a hoodie walking toward his girlfriend's house, stopped, handcuffed, searched without cause. A black delivery driver waiting outside a gated community, detained and questioned while his customer's food went cold. A real estate agent showing a house in Westwood Terrace, stopped, interrogated, told he did not match the listing. Each complaint followed the same arc: filed, reviewed, closed, sometimes with a mild recommendation for de-escalation training, sometimes with nothing at all. One supervisor noted that Voss had strong instincts but needed to develop greater community awareness. Another wrote that he was effective in law enforcement, though occasionally rigid. No one connected the dots. No one asked why those instincts always flared when the driver was black and the zip code began with the same numbers. His colleagues called him by the book. Off the record, some said what others would not. He pushes too hard. He turns parking tickets into mountains. It's like he's looking for a fight. Yet he was never officially reprimanded. His stops produced enough citations to satisfy his superiors, and his reports were always meticulously written, precise language, flawless justifications on paper. Risk management flagged him quietly twice based on stop and search data. Both times they were told to focus elsewhere, and so Voss kept patrolling, kept stopping, kept deciding who belonged and who did not. Until one quiet afternoon, he saw a black woman in a black BMW turning into a driveway on Crest Hill and, without checking plates, property records, or context, made a decision that would end his career and cost the city a heavy price. Crest Hill was the kind of neighborhood the brochures call charming, the kind of place where yard signs say, "Love lives here," yet unspoken rules still governed who woke suspicion. A small enclave just west of downtown, known for its safety, its good schools, and the exacting standards enforced by the Homeowners Association. Red brick colonials with stone chimneys, curved driveways lined by geometrically trimmed boxwoods, no trash bins in sight, no basketball hoops in front yards, streets named after trees, Sycamore Lane, Elm Grove, Horn Circle. It was a clear spring afternoon, soft light slanting through the flowering dogwoods. Children were just returning from school. Retirees walked golden retrievers in polite silence, the kind of afternoon when everything looks exactly the way it is supposed to look. Into that picture drove a black BMW, smooth and quiet, turning onto Elia Drive. Judge Avery Hale was coming home. She had just finished a full day of hearings at the downtown state courthouse, still wearing her black judicial robe, the court parking pass still hanging from the rearview mirror. She had slipped off her heels. They rested on the passenger seat. Flat shoes were on her feet. Her braided bun had loosened slightly. After a long day on the bench, she was thinking about dinner, about her niece's upcoming college visits, about whether her mother had remembered to take her afternoon medication. Her mind was on the ordinary details of a full life, not on being seen as a threat. She slowed, signaled, and turned into her driveway. The second house on the right. Brick facade, black trimmed windows, azaleas blooming on either side of the front porch. A house she had bought with her own money years earlier, paid for in full, title in her name. She put the car in park and leaned over for her briefcase. That was when she saw the patrol car stop behind her. No siren, no lights, just a slow, deliberate stop, blocking the rear of the driveway. The door opened. A white officer stepped out, hand already near his belt, sunglasses still on, gaze fixed on her windshield, then on her face, then on the car. Officer Gage Voss did not see a homeowner returning from work. He did not see a judge. He saw an intruder. something that, in his mind, did not belong on Elia Drive. And in that moment, titles, robes, mortgages, facts all stopped mattering. Judge Avery Hale had spent more than half her life inside courtrooms, not as a spectator, not as a defendant, but as someone trusted to interpret the law when lives, liberties, and futures hung in the balance. She was the first black woman ever appointed to the State Court of Appeals, a milestone reached after years of work so methodical, so disciplined, that little room remained to question how she had earned it. Harvard Law, top of her class, law review editor, a federal clerkship that nearly broke her under the workload, yet sharpened her instincts. Years as a prosecutor known for something rare in that role, restraint. She did not overcharge. She did not grandstand. Defense attorneys trusted her word. Judges trusted her judgment. Even defendants who lost cases often acknowledged that she had been fair. That reputation followed her onto the appellate bench, where she became known for opinions that were precise, clear, and difficult to overturn. She was not flashy. She did not chase headlines. She believed the law mattered because people mattered. Outside the courtroom, her life was quieter than most expected. She lived in Crest Hill, not for status, but for proximity. Close to the courthouse, close to her mother's doctors. Her mother, Eleanor, was in the early stages of Parkinson's. Some days were good, others were not. Avery handled the hard days the same way she handled the bench, with calm, preparation, and patience. Her niece Olivia lived with them as well, 16, bright, restless, already talking about law school because she had grown up watching her aunt read case law at the kitchen table. Avery liked the house to feel full, lived in. She liked being needed. Crest Hill neighbors knew her as polite but reserved, the woman who waved, kept her garden immaculate, and quietly hosted a small graduation party each June for the interns who had passed the bar. Some were surprised when they learned she was a judge. Others were not. What no one questioned was that she belonged there. She paid her taxes. She served her community. She defended the same laws Crest Hill claimed to value. She had argued constitutional principles for decades. She had sworn to uphold fairness and equal protection. She believed in the system enough to work inside it for her entire adult life. That is why what happened next was not merely an arrest. It was a rupture, a moment when everything she had spent decades defending turned against her without hesitation. Officer Gage Voss was not even assigned to Crest Hill that afternoon. He was not responding to a robbery, a traffic accident, or a domestic call. He was simply patrolling the neighborhood after dispatch broadcast a vague report. Suspicious vehicle, unknown occupant, Elia Drive. No plate number, no reported crime, only suspicion. Voss slowed as he turned onto the street, scanning driveways the way he always did, looking for anything that did not fit his internal map of the neighborhood. Then he saw it. A late-model black BMW, clean, turning into a driveway mid-block. A black woman at the wheel. He made his decision in seconds. He did not run the plates. He did not wait to see if she stepped out of the vehicle with her keys. He did not check property records, though he could have done so from the patrol car. The dashboard camera would later show him braking hard and stopping behind her car before she had fully settled. The Ring camera, mounted above the garage, captured the same scene from another angle. Vanessa's car still moving, reverse lights glowing, Voss's door opening, his boots hitting the pavement. Avery felt it before she fully registered it. The presence, the shift. She looked in the rearview mirror and saw the patrol car blocking her exit. No lights, no siren. Just an officer approaching quickly, one hand already resting near his weapon. She had not even put the car fully in park. She was still leaning. He stepped to the driver's window, posture rigid, voice sharp. "Turn off the engine, now." Avery froze for half a second, startled more by the aggression than by the interruption. "Officer, this is my house," she said evenly, her tone instinctively measured, the same tone she had used in courtrooms for decades. Voss did not acknowledge the words. He did not ask her name. He did not ask why she was there. His eyes moved from her face to the interior of the car, cataloging, judging. In his mind, the call had already been confirmed. Black woman, expensive car, Crest Hill driveway. Suspicion justified. He stepped closer, invading her space as neighbors began looking up from their yards. "Step out of the vehicle," he ordered. Avery had not even opened the door. She had not raised her voice. She had not resisted anything. But Voss had already decided it was her. And once that decision was made, the facts stopped mattering. She did not have time to process what was happening before the situation turned aggressive. Voss approached her window with a wide stance, one hand already near his weapon. "Step out of the vehicle, now," he barked. It was not a greeting. It was not an explanation. Only volume and authority. Avery stayed calm. She always did. She lowered the window and looked at him directly. "This is my house. I am pulling into my driveway." Her voice was serene, measured, controlled. But Voss was not listening. His eyes scanned her face and then dismissed her words entirely. "Matches the description," he said. "I told you to get out of the car." What description? There was none. Only black woman, BMW, Crest Hill. But for him it was enough. Enough to escalate. He did not ask for her license. He did not ask her name. He asked no clarifying question that might have ended the encounter before it began. Instead, he grabbed the door handle and yanked it open without warning. Avery's seatbelt was still fastened. The car was still running. She turned, startled. "Please, I have done nothing." Voss did not answer with words. He leaned in and tried to pull her out by force. The seatbelt stopped the motion. Her body jerked forward and caught. She winced in pain. "Unbuckle it," he ordered, as if she were deliberately challenging him. The neighbor's Ring camera later showed her raising her hands, unbuckling slowly, trying to de-escalate something he had already turned into fire. "I live here," she repeated. But for Voss, compliance was not enough. Identity did not matter. He wanted control, and he was not leaving without placing handcuffs on someone. Avery stepped 1 foot out of the car, kept her hands visible. She was calm, deliberate. The moment she fully exited, Voss seized her wrist, twisted it behind her back, and shoved her against the hood. Her robe flared around her. Her briefcase hit the ground. Her head snapped against the warm metal. "Stop resisting," he shouted, even though she had not moved. The street was silent, except for the sound of keys falling and her voice repeating, over and over, "I live here. This is my house." She tried one last time, raising her voice only enough to be clearly heard. "I am Judge Avery Hale. I live here. This is my house." He did not stop. He did not hesitate. He did not process anything. He twisted her arm harder and pressed her against the hood, her cheek against the warm metal. "I told you to stop resisting," he snapped again, a phrase he knew would sound good in a report, even though body camera footage would later show the opposite. Avery kept her voice steady. She had no intention of giving him a reason to claim she was combative. "My identification is on the passenger seat," she said through gritted teeth. "My court credentials are on the dashboard. My parking permit is visible. You are making a mistake." But Voss was not interested in credentials. He did not look. He did not verify. He did not slow down. Because in that moment, for him, none of it mattered. The credentials on the dashboard, the ID clipped to her briefcase, the permit, the robe, the history, all of it was irrelevant. He saw a woman challenging his order, not explaining, not resisting, simply existing in a way that did not fit his assumptions. "You're obstructing," he said, tightening the cuffs behind her back. "You're trespassing on private property." "I am in my own driveway," she answered. "This is my house." But the facts were not driving anything. What ruled was the impulse to arrest. Voss was not going to be contradicted in front of a quiet street and a recording ring camera. He had made his decision the moment he stepped out of the patrol car, and now he was committed to it. Across the street, a neighbor appeared behind a screen door, watching, recording, too stunned to intervene yet lucid enough to know something was terribly wrong. Avery looked up from the hood, robe wrinkled under her shoulder, knees pressed against the pavement. She was still calm, still controlled, still a judge. But in that moment, none of it mattered, not to the officer who had decided that authority needed no proof, only a target and enough noise to justify the charge. The silence held until it broke. The thud of Avery's briefcase hitting the ground, the dry metallic click of the handcuffs closing, the sound of authority applied without reflection. Then came the quieter silence that always follows violence when no one knows what to say. That was when the phones came out. One neighbor positioned himself behind a mailbox, recording with trembling hands. Another filmed from behind a curtain. A teenager on a bicycle stopped at the corner and pressed record. "The footage is public now." You can hear Avery's voice, measured, firm, trying to cut through the panic. Please, I am a judge. My name is Avery Hale. This is my house. My mother is inside. She was not screaming. She was not thrashing. She was narrating, documenting, bearing witness to her own arrest. Voss did not acknowledge it. He did not stop. He gripped her shoulder and marched her roughly toward the patrol car. Avery was barefoot. Her heels were still on the passenger seat where she had left them. She shuffled down her own driveway, hands locked behind her back, black robe tangling around her legs. She looked exactly what she was, a professional. Composed woman being mistreated. "This is a mistake," she said again. "My neighbor has a Ring camera." She was pleading. She was warning. It did not matter. Voss opened the rear door and pushed her inside. The back seat of a patrol car, cracked vinyl still hot from the sun. Avery's knees hit the doorframe as she slid sideways, trying awkwardly to keep her dignity in the face of the absurd. "I don't care who you are," Voss muttered as he closed the door. His voice was captured on the neighbor's recording and would go viral before nightfall. 4 seconds that reduced a career to a single sentence. Avery sat in the back of the patrol car, breathing measured, eyes forward. She had spent years presiding over cases of illegal arrests, police misconduct, unjustified detentions. She never imagined she would live one, but now, in her own driveway, she was no longer a judge, no longer a homeowner, no longer anything but a handcuffed, barefoot woman treated as an intruder on the land that belonged to her. The patrol car pulled away from the curb, past immaculate gardens and stunned neighbors, leaving behind a house, a mother who did not yet know what was happening, and a city about to pay the price for a decision that had taken less than 3 minutes. The ride to the station lasted only a short while. Avery counted every turn, not out of panic, but out of precision. That is what judges do. They count. They document. They remember. She noted the turns, the speed, the silence. Voss said not another word. He did not even glance in the rearview mirror. When they arrived, he parked without hurry, got out, opened the door. He offered no help, only barked, "Let's go." Avery stepped out slowly, hands still cuffed behind her back, shoulders straight, robe dragging slightly at the hem and catching on the uneven pavement. Her hair had frizzed at the edges. Her shoes were still missing. She walked barefoot through the side entrance of the station, past uniformed officers who stopped mid-conversation at the sight of her. At the booking desk, a young sergeant looked up and froze. Recognition spread across his face. "Judge Hale?" Avery nodded. "Yes, Avery Hale, State Court of Appeals. I was arrested in my own driveway without cause." The sergeant looked from her to Voss, who stood to the side with arms crossed and jaw tight. "What the hell is going on?" Voss did not flinch. Non-compliant subject, matched a suspicious vehicle report, refused to exit the vehicle, claimed to be a judge. The word "claimed" hung in the air like smoke. The sergeant looked back at Avery. The court parking pass, the unmistakable face from hundreds of hearings and legal filings. "Lieutenant," he called. In less than a minute, Lieutenant Patricia Vale appeared, years on the job, zero tolerance for nonsense. One look at Avery and her expression changed. "You're telling me you arrested Judge Avery Hale in her own driveway?" "She refused to comply," Voss said. Vale did not answer him. She turned to the sergeant. "Get those cuffs off. Now." The sergeant obeyed at once. The moment Avery's wrists were free, she rubbed them gently, then clasped her hands in front of her. "Thank you," she said, voice steady. "I want this incident documented in full. Video, audio, everything." Vale nodded. "It will be. I'm very sorry, Judge Hale. You never should have been brought here." Voss shifted slightly, but remained silent. No apology, no acknowledgement. Only the quiet crumbling of authority, built on assumptions and poor judgment. Within the hour, the news reached the chief's office. By the next morning, the city would be in crisis, but the damage was already done. It began with a neighbor's phone video, 93 shaky but clear seconds of a barefoot black woman in a black judicial robe, handcuffed and pushed into a patrol car while she said calmly, "This is my house." A white officer answering, "I don't care who you are." The clip hit social media before dinner. Within hours, it was on the front page of the local news site. By evening, national outlets had picked it up. The headline practically wrote itself. "Black judge mistaken for criminal in her own driveway." By midnight, it was national news. The Ring camera across the street, time-stamped and crystal clear, showed Officer Gage Voss grabbing Judge Avery Hale before her car was fully parked. Dashboard camera audio obtained through a public records request added weight. Her calm against his escalation, her credentials against his contempt. Nothing was ambiguous. There was no blurry context, no competing narrative. It was exactly what it looked like: an illegal arrest of a respected judge in her own driveway for the crime of parking while black. Civil rights organizations responded first. The NOACP issued a statement before dawn calling the arrest a shameful example of racial profiling and institutional failure. The National Bar Association followed hours later. No judge, no citizen should be criminalized in their own driveway, least of all someone with decades of public service. Lawyers, associations, law school deans, prominent jurists, community leaders all condemned the incident. Hashtags began trending. Justice for Judge Hale. Black at home. Avery herself issued a brief statement through her attorney. It was serene, direct, precise. I was handcuffed, barefoot, and humiliated in my own driveway while identifying myself as a judge and a homeowner. I will not allow this to stand, because if it can happen to me, it can happen to anyone. Public fury was immediate and deafening. Local radio lit up. Editorials flooded the papers. Online forums exploded. A woman with power, status, and credentials, still not safe from assumptions, still not spared the use of force. The mayor's office issued a vague statement about reviewing the facts. It was not enough. Pressure kept rising. The city had not merely arrested a judge, it had struck a match in a dry forest. And now everything was burning. By the following afternoon, the mayor was on the defensive. Press surrounded City Hall. The mayor's press secretary canceled 3 scheduled events. We are treating this with the utmost seriousness, she told reporters, reading a prepared statement that said everything and nothing. Behind the scenes, things moved faster. Council members demanded answers. Emails flew. Meetings were called. The police chief, under intense pressure, opened an internal affairs investigation before the day ended. Officer Gage Voss was placed on administrative leave, standard language. But this time it meant something different. His name was already out there. So was his history. 7 prior complaints, 4 for use of force, 3 for racial profiling, all investigated internally, all dismissed. Until now, that history had been invisible to the public. Now it was on the front page. The complaints drew a clear pattern. Voss stopping black residents in affluent areas, aggressive tone, unnecessary escalations. Each time, his reports told a cleaner version than reality. The department had chosen image over action. The Oversight Council had once flagged him as low priority. The union backed him. Command looked the other way. Voss was seen as proactive, a cop who did not back down. Now all those descriptions looked like ignored warnings. One council member called it a systemic failure. Another labeled it a completely predictable outcome. Voss's body camera footage had not even been released yet, but it no longer mattered. The Ring video and the neighbors' recordings had already shaped public opinion. Officials claimed the investigation would be thorough and independent, but residents were not asking for another report. They wanted accountability. They wanted action. The police union issued a short statement defending officers' right to assess threats in real time. It did not help. The backlash only grew louder. Retired judges began speaking out. Local law professors offered analysis. Even conservative commentators expressed shock. How could a judge, someone known in every legal circle, be dismissed so easily, treated so roughly? City officials knew what was coming. Lawsuits, protests, policy reviews, nightly news segments, the kind of storm that does not pass quickly. And at the center of it all was a driveway, a pair of handcuffs, and a black woman who had done everything right and still ended up in the back of a patrol car. Judge Avery Hale did not rush to file the lawsuit. She waited. She let the facts accumulate in plain sight. She let the city respond. She let the department twist. Then, weeks after the arrest, her legal team filed a federal civil rights lawsuit that landed like a gavel strike. 57 pages of precision and weight, allegations backed by timestamps, recordings, history, and law. The suit named the city, Officer Gage Voss, the police department, and several members of command in their official capacities. The charges were clear: unlawful arrest, excessive force, racial profiling, violations of the 4th and 14th Amendments, public humiliation, and intentional infliction of emotional distress. But the lawsuit was not only about that Tuesday afternoon. It was about a pattern, a department that had 7 chances to rein in a single officer and chose not to. Her attorneys laid it out with surgical detail. 7 prior complaints against Voss, all dismissed. 4 alleged aggressive physical force. 3 pointed to racial bias during traffic and pedestrian stops. In every case, the department's response was identical. Minimal internal review, no discipline, training modules that were never monitored. The complaint included internal documents obtained through a whistleblower, emails from supervisors flagging Voss's conduct, memoranda describing tension with minority community members, performance evaluations coded with phrases like assertive field tactics and officer safety-first mindset. One lieutenant had written that Voss appeared to escalate routine stops, particularly when they involved residents of color. That memorandum never left the desk. Avery's legal team used her status not as a shield, but as a measuring stick. If a sitting appellate judge, clearly identified, calm, unarmed, and standing on her own property, can be arrested violently without cause, the complaint stated, what protection exists for anyone else? The lawsuit drew national attention. Civil rights groups called it a landmark case in the making. Legal scholars described it as the rare kind of suit that challenges not only conduct, but the system that allowed it. The city's legal team called it complex. Others called it indefensible. The dollar figure was not specified, but the message was. The case was not only about what happened in one driveway, it was about everything the department failed to do in the years leading up to that moment, and about how silence, over time, becomes policy. Discovery cracked open the department's internal operations like a vault. What emerged was not mere negligence. It was complicity. Deposition after deposition, the story stayed the same. Officers raised concerns. Supervisors acknowledged patterns. Nothing happened. A former sergeant admitted under oath that Voss was known for pushing limits. Everybody knew, he said, but he generated stats. Another lieutenant, still active, testified, we flagged his stops years ago. It got buried in the command stack. Nobody wanted to own it. Emails revealed still more. Years earlier, a field supervisor had sent a report to senior command noting Voss's disproportionate rate of stopping black drivers in predominantly white neighborhoods. The email ended with a simple question. Are we monitoring this officer closely enough? No one answered. Internal Affairs had reviewed Voss on 3 separate occasions over the years. Each time, the file was closed for insufficient evidence, despite civilian witnesses and body camera inconsistencies. One review committee member wrote privately in an email, "This officer is going to cost us a lawsuit someday." He was right. Most damning of all was a memorandum from the department's own risk management office, dated well before Judge Hale's arrest. Subject, Officer Gage Voss. Recommendation for field conduct monitoring. Review of complaint patterns and stop data suggests Officer Voss unnecessarily escalates during routine stops, particularly those involving black residents. Supervised ride-alongs and focused retraining on de-escalation and bias response are recommended. The memo was marked reviewed but never acted upon. During questioning, a deputy chief acknowledged having read it. We didn't implement it because we were dealing with union pressure over previous disciplinary cases. We had to pick our battles. That phrase would haunt the city's legal team throughout the case, a department that chose the wrong battles, a leadership team that gambled with risk and lost. Avery's lawyers used everything, every ignored email, every paper trail that stopped halfway, every officer who said, "I tried to speak up, but no one listened." The judge's arrest was no longer an isolated incident. It was proof of a culture that treated complaints not as warning signs, but as paperwork. And in a courtroom where truth mattered, that culture was now on trial. It took months of depositions, public pressure, and rising legal bills before the city finally folded. The evidence was undeniable. The footage was everywhere. The outrage had not faded. The lawsuit was not merely solid, it was devastating. In a closed-door meeting, the city's attorneys briefed council members on the likelihood of losing at trial. One of them reportedly said, "We don't just have exposure, we have liability, carved in stone." The settlement was finalized that same week. $820,000 paid to Judge Avery Hale, a historic figure, one of the highest in the state's history for an unlawful arrest involving a judicial officer on private property. The check was a formality. The admission came in the accompanying language. The city acknowledged that constitutional rights had been violated, that Avery had been subjected to force and detention without legal basis, that the officer who made the arrest, Gage Voss, had a documented history that should have triggered additional scrutiny. A week later, the police chief issued a formal apology. It was read aloud at a public hearing, cameras rolling, microphones open. The arrest of Judge Avery Hale was unjustified, inappropriate, and in direct violation of our department's policies and the principles of constitutional policing. On behalf of the department, I extend my deepest apologies. It was not enough, but it was more than most people ever receive. As for Voss, he was fired. The termination letter was direct. Officer Voss failed to conduct a lawful detention, failed to de-escalate, failed to verify identity, and used unnecessary force against a civilian later confirmed to be a sitting appellate judge on her own property. This incident, combined with a documented history of similar conduct, renders Officer Voss unfit for continued service. His name was entered into the National Decertification Index, a list created to prevent fired officers from quietly transferring to other departments. His badge was gone. His career was over. The police union considered filing a grievance, but after reviewing the internal investigation and deposition transcripts, it withdrew. There was no case to defend, not when the entire country had already seen what happened, not when the court of public opinion had already rendered its verdict. The department apologized. The officer was fired. Yet justice, as Avery would later say, costs more than money. It costs the assumption that you belong where you are, even in your own driveway. The press conference was held on the steps of the courthouse, the same courthouse where Avery Hale had presided for more than a decade. She stood behind the lectern in a navy suit. She was not wearing her robe. There was no entourage, no theatrics, only strength, clarity, and a truth she was no longer willing to let others define. Cameras clicked as she began. "Good morning. My name is Avery Hale. I am a judge of the State Court of Appeals. I interpret the law. I uphold the Constitution. I protect the rights of every citizen who appears before me." She paused. She let the silence settle. "And I was treated as a suspect in my own driveway because of the color of my skin." The crowd remained silent. Press, colleagues, activists, ordinary citizens, all listening. I was handcuffed, barefoot, pushed into a patrol car while my credentials were in plain sight. I stayed calm. I followed every instruction. None of that mattered. She spoke without notes, without emotion clouding her voice, only fact after fact. If this can happen to me, with my education, my position, my record, my standing, what happens to those who have no titles, no credentials, no cameras? What happens to the young man walking home after work, to the woman pulling into a friend's driveway, to someone no one is watching? Her voice rose only a little, controlled, firm, resolved. This was not only about one officer. It was about a system that ignored 7 complaints, that rewarded escalation, that did not act until the public forced it to. She closed the folder in front of her, but did not step back. I reached this settlement not because money restores dignity, but because accountability has to start somewhere. I am still a judge. I am still a homeowner. I am still a citizen, but I will never erase that moment in my driveway. She paused one last time. So I ask this city, what are we doing to ensure the next person is not handcuffed before they are heard? And will we only believe people when they wear a robe? Or will we believe them when they say, "I live here, and that is enough"? With that, she stepped back. The cameras kept rolling, but the silence of the crowd said more than any lens could capture. The headlines faded, the protests quieted, the settlement was paid, the officer was fired, the apology was issued. Yet the real question hung in the air like mist after a storm. What actually changes? City officials rushed to prove this was not merely damage control. They announced reforms, measured, structured, written in the formal language of bureaucracy, yet real. Effective immediately, officers were required to verify identity before initiating physical contact unless an immediate threat to safety existed. No more detain first and verify later. A new policy. Any officer with 3 or more complaints for racial bias or excessive force within a 24-month period would automatically trigger an internal audit. No discretion. A new public database was launched to track stop data by race, searchable by precinct, officer, and outcome. It was designed to surface patterns rather than bury them in paperwork. And, most significantly, a civilian oversight board was created, composed of community members with subpoena power and access to disciplinary files. No more closed-door investigations. No more invisible misconduct. For the first time, residents had a seat at the table and the authority to hold officers accountable. The mayor called it a new chapter. The police chief called it a cultural reset. The public called it long overdue. They were not perfect solutions. They did not erase what had happened in Avery Hale's driveway. They did not erase the 7 ignored complaints that came before, but they were more than nothing. They were movement, progress born of pressure. Still, Avery herself remained measured in her response. In a private roundtable with legislators, she stated it clearly. Policies are only as strong as the people who enforce them. We cannot legislate bias out of existence. We cannot write enough rules to undo a mindset that sees black skin as suspicious by default. That was the truth beneath the reforms. That was the hard part, the part that does not change with memoranda or mandatory trainings. Because behind every unjust arrest is a decision, a moment when judgment yields to assumption, when power overrides listening, when presence becomes presumed threat. So yes, the city changed policies, published data, fired an officer, paid a judge. But the real test is not whether it avoids the next lawsuit. It is whether it prevents the next Avery Hale, the next person arrested in their own driveway, forced to prove they belong. Because until that stops, we have not changed nearly enough. This case was brutal, and if this can happen in a person's own driveway, it can happen anywhere. Do not look away simply because it did not happen to you. Power does not protect you when prejudice decides first. Silence is not neutrality. It is permission. Accountability exists only when people demand it. Question authority when it acts without evidence. Listen when someone says, "I live here," because justice survives only when we refuse to let it be ignored. If this story moved you, share it, because silence helps no one. Your voice matters more than you think. And stay with us for more stories that demand justice, truth, and accountability.